This is the first paper that I've written in this particular field, so my colleagues who are here today are very surprised to see me here today presenting on this particular topic. So my background is in legal philosophy and constitutional law. So how this paper came about was that my colleague, Dr. Adrian Owen, approached me and asked me if I was interested in thinking about the legal implications of his research. So let me talk a little bit about his research before I discuss what I think are the potential legal implications of his research. So Dr. Adrian Owen, you may have caught him on television once in a while. He does work with, he's a neuroscientist who does work with individuals who are in a semi-conscious state or vegetative state. And what he tries to do is discover people who are there, but they don't appear to be there. So according to traditional medical tests, these individuals are simply no longer present. But the traditional medical tests rely on physical stimuli to create reactions, and then the patient is diagnosed. What Adrian does is he uses technology, specifically functional MRIs, in order to detect consciousness in patients that weren't deemed to be conscious. And his research is really interesting because what he does is he puts patients in the functional MRI, and then he asks them questions. And he asks them to imagine playing tennis if the answer is yes, and to imagine walking room to room if the answer is no. So what you end up getting, if the patient has covert awareness, is a brain pattern, a brain scan that's very complex. So he photographs these brain scans and he will argue that this is evidence that the patient is actually more aware than we think that the patient is. And his research took another turn fairly recently when his colleague, Dr. Nasi, and himself decided to show patients, two patients actually, who were in a vegetative state, Alfred Hitchcock films. And what they wanted to see is whether the brains reacted to the moments of suspense in a way that was quite similar to the brains of everyone else. And they did find that one of the patients had a reaction that was very similar. And this is interesting and very strong evidence of what he's trying to prove because of the complex nature of the reaction, and also because what films of this kind do is they play on your subconscious in a particular way. So it's not about thinking the same thoughts as everyone else. It's actually about having a reaction like anybody else would have if they were not in this particular situation. So it's fairly interesting research, and the question is, how does this research intersect with law? It doesn't take us too much time to figure out how this would happen, and it has happened. So what happens is when somebody is deciding whether or not to remove life support, one of the options is to figure out if the person is actually more aware than they appear. So are you removing life support from a patient who's gone, or are you removing life support from a patient who's actually more aware than they are, than you think that they are? So the nightmare scenario is you're talking about removing the feeding tube from a particular patient, and it turns out they can hear you and they understand what's going to happen, and they have no say, and you simply don't know what you're doing because you assume that they are no longer there. So there's a case, Ning and Ning, and this is the case that I will explore today. So in Ning and Ning, what happens in this particular case is Kenny Ning has been in a car accident, and for 6 years he's been in a minimally conscious state, which means that he has the normal automatic reactions of anybody else, but he doesn't actually communicate verbally or in any meaningful way with his family or his physicians. He does open his eyes on occasion and make certain movements, but these movements were deemed by his doctors to be meaningless. So we have this patient, and after 6 years of being in this particular state, his wife Laura decides that she wants to remove his feeding tube. And she was met with opposition from his family. So his family wanted to send Kenny to London, Ontario, in order to be tested in the fMRI machine that Dr. Owen has. They wanted to figure out if he was more aware than they thought he was. And they went to court in order to try to get Laura removed as the legal committee of the person. And in the case, which is a BC Supreme Court case, Laura was successful and Dr. Owen's research was not used. But in that particular case, when we have a look at that case, we find that the judge has misunderstood the nature of the research. So while I think it's quite challenging for Dr. Owen's research to meet all the requirements in the current legal test for expert evidence. Once we look at the particulars of the case, it becomes clear that this was a missed opportunity. Justice Groper did not even apply the relevant test, so we don't know exactly how strong or how weak Dr. Owen's evidence would be treated by a court. So when we turn to this particular case, what we find is that Justice Groper made 3 errors, in my view. So what she did initially was she argued that Dr. Owen was unable to provide any additional evidence that would change the diagnosis. Kenny's doctors have already diagnosed Kenny as being in a minimally conscious state, and Dr. Owen was hoping to do the same. But what she misses, in my view, respectfully, is she misses the possibility that Dr. Owen would identify covert awareness that was not there. So while Dr. Owen uses the same term, minimally conscious state, he uses it in a radically different way than Kenny's doctors. So her failure to recognize the way in which these words are used differently by different practitioners means that she underestimated the potential of Adrian Owen's research. So for this reason, we believe that she should have recognized the potential of the research and applied the relevant legal test. She makes 2 other arguments that I also think are slight missteps. One argument is that she argues that even if Dr. Owen was able to identify covert awareness in Kenny, there's still no possibility of a cure. And I agree. So Kenny is not likely going to be cured. But the ethical calculation that one would undertake when removing a feeding tube would be radically different if covert awareness was discovered. So also notice that what Dr. Owen wants to do is actually simply realize the exact same aim that Kenny's doctors wanted to realize. Both parties want to figure out how to accurately diagnose his state. It just amounts to a paradigm shift in terms of the way in which they access that information. So Kenny's doctors, as mentioned earlier, use physical tests. Dr. Owen wants to go into the brain. Okay, and there are some problems with this. There are some questions that linger. But nevertheless, they're aiming at the same bit of information. So regardless of whether or not a cure is going to be on the horizon, it's my view and the view of my co-authors that, in fact, it's an important ethical issue that could then lead to a different outcome for Kenny if Adrian Owen discovers covert awareness. And finally, one of the other reasons offered by Justice Groper was the fact that transporting him from BC to London, Ontario would be quite dangerous and risky given his ill health. I thought this was a poor argument because Kenny faces certain death if they don't carry out the test, so the risk of death seems to be a point that was beside the point. And one of the points I want to make, so I'm not going to go through the way in which my colleagues and I apply the legal test for the admission of expert evidence. But one of the things that we want to make an argument for is it's actually the stakes in this case that help Adrian Owen possibly overcome some of the legal hurdles. So the stakes are life and death, so they seem high. But the option is always certain death. So if you're worried about things like mystic infallibility, the idea that the jury or the judge might take his evidence as true simply because it's so impressive and they can't themselves figure out another way to question the evidence, we're not as worried about this for a number of reasons. But one of the reasons is if Kenny displays covert awareness and his brain lights up because he's watching an Alfred Hitchcock film, so there's strong evidence that he has more activity taking place than previously thought of. So the possibility of a false positive is fairly low, and actually Adrian Owen thinks it's not possible. And then second, if you don't test him, he's going to die. So there are worries around false positives and false negatives and mystic infallibility, but the option is death. So once you put it in the life and death context, that context actually speaks to the recognition and not against the recognition of using Dr. Owen's research in a court of law. And we can compare this to things like lie detection, where the stakes seem to be lower in one sense. So if you use fMRI technology for the purposes of lie detection, the error rates are problematic, and then somebody might end up in prison for the rest of their lives because of faulty fMRI results. So the stakes seem lower when we're dealing with lie detection, but actually I think they're much higher. And in the context of his research and the way it's being used, we believe that the case for his work to be entered into the courtroom is fairly strong, not perfect, will become stronger through time, but it's strong in part because of the context of the situation that we're dealing with.